Imagine this. A California physician is arrested on criminal charges, perhaps related to patient care, prescribing practices, or personal misconduct. At the first court appearance, before any trial, conviction, or even full discovery, the judge orders the doctor's medical license suspended as a condition of bail. Overnight, the physician can no longer see patients, perform procedures, or earn a living in their chosen profession. The Medical Board of California has just used a little-known tool in the criminal justice system to protect the public before the case is even decided. This isn't hypothetical. It happens under California Penal Code Section 23. What is Penal Code Paragraph 23, and why does it matter for doctors? Enacted to let licensing agencies protect the public when one of their licensees faces criminal charges, substantially related to the qualifications, functions, or duties of the profession. Penal Code Paragraph 23 gives state agencies like the Medical Board of California the right to show up in criminal court. The board, usually represented by a deputy attorney general, can voluntarily appear and provide information to the judge, recommend specific conditions of bail or probation, ask the court to suspend the physician's license outright while the criminal case is pending. This is separate from the board's own administrative disciplinary process. It's a fast-track intervention happening right in the criminal courtroom, often at arraignment or the bail hearing itself. Common triggers for physicians include charges involving sexual misconduct with patients, overprescribing or diverting controlled substances, healthcare fraud or insurance billing crimes, domestic violence or other conduct the board views as showing unfitness to practice. In these scenarios, the board argues that allowing the doctor to continue practicing poses an immediate danger to patients. The due process battle. Gray and Naidu set the rules. This power isn't unlimited. Two key Court of Appeal decisions have drawn important lines. In Gray v. Superior Court, 2005, the First District struck down an ex parte, no-notice order banning a Napa psychiatrist from practicing as a condition of bail. The court ruled that due process requires notice, a hearing, and evidence showing an immediate risk to the public. You can't just yank a professional license based on unproven allegations. Then came Naidu v. Superior Court, 2019. The appellate court held that the licensing agency must actually prove the licensee is dangerous if allowed to maintain their license. That means presenting testimony and documents, not just showing up and asking for suspension. Criminal defense lawyers now use Naidu to demand a real evidentiary hearing. Still, the practical reality for many physicians is brutal. Bail hearings happen fast, discovery may be incomplete, and judges, understandably concerned about patient safety, often err on the side of caution. Why this feels so unfair, and why the board does it. From the physician's perspective, it's a presumption of innocence nightmare. You're not yet convicted. Yet your ability to practice medicine, the skill you spent a decade or more training for, is stripped away, sometimes for years, while the case drags through the system. Patients suffer too. Surgeries get cancelled, chronic pain, patients lose their doctor, rural clinics lose their only provider. From the medical board's viewpoint, the stakes are existential. The board's mandate is public protection. If a doctor is accused of something that could harm patients, waiting for a criminal conviction, which can take 1 to 3 years, is unacceptable. Better to suspend now and sort it out later. The board can also pursue an interim suspension order through its own administrative process, but Penal Code Section 23 gives them a quicker, parallel route directly in criminal court. Real-world impact and how to fight it. Physicians facing PC Paragraph 23 requests often see their practices collapse. Hospitals revoke privileges, insurers drop them, malpractice carriers cancel coverage, and income evaporates. Even if the criminal case ends favorably, rebuilding a medical career after a public suspension is incredibly difficult. Defense strategy matters enormously. A strong response usually involves coordinating criminal defense counsel with a specialized medical license defense attorney from day one, demanding the evidentiary hearing required by Naidu, presenting mitigating evidence, character letters from colleagues, evidence of rehabilitation, alternative bail conditions such as electronic monitoring and practice restrictions instead of full suspension, challenging whether the charges are truly substantially related to the license. The bottom line: California's use of Penal Code Paragraph 23 in physician criminal cases reflects a clear policy choice. When a doctor's alleged conduct could endanger patients, public safety trumps the normal presumption of innocence, at least temporarily. Whether that balance is right is a legitimate debate. What's not debatable is that any California physician facing criminal charges must treat the bail hearing as seriously as the trial itself. If you're a physician, the moment charges are filed is the moment you need dual-track counsel. One lawyer for the criminal case, another laser-focused on protecting your license. The system moves fast, and the stakes are your entire career. Daniel Horowitz is expert in defending physicians, and he has vast experience fighting license suspensions pending trial. Call Daniel Horowitz at 925-283-1863. Again, that number is 925-283-1863.